On behalf of the Sentencing Commission, Chairman Judge Robert Devlin, and our entire membership of the Sentencing Commission, we welcome you all here.
What money bail does is it basically says, well, if you're a flight risk and you're dangerous, we'll let you out because you're wealthy. And if you're not a flight risk and you're not dangerous, we're going to put you in prison because you're not.
There's a toll paid by our communities and victims. Even a few days in jail makes a low-risk person more likely to come out a higher-risk person and commit a crime in the near future.
Would Connecticut be a better state, a fairer state, a more just state, and a safer state if we made our bail system different?
Whether the amount of money required for release is read from a piece of paper and is the same for every single person charged with a particular crime or who has a particular criminal history, or whether it's plucked from thin air based on the whims of the judge and his mood that day. If the amount is determined without reference to a person's ability to pay it, and the sum operates to detain only impoverished arrestees, without any findings that pretrial detention is necessary to address a specific risk, then it violates equal protection and due process.
I'm a full professor at a state university. I've had tenure for 11 years. So if you believe the popular media, I have pretty decent job security, and I do. I'm not going to stand up here and say that I don't. By the same token, if I disappeared into a jail cell for 5 to 10 days, I'd have some serious problems. And if it happened a second time, I'd be bounced. They would bounce me. I have absolutely no doubt. So think about that when you think about the person who is not a tenured professor or a long-standing member of the bar, for example. Think about the person who's working full-time in the fast food industry. In other words, they're highly replaceable. Who have custody of school-age children, who are sharing an apartment with a friend and their name's not on the lease, who's living check to check. What would happen to all of those domains if they had to spend 5 days in jail, or maybe even just 24 hours?
How did we end up with a system that bases pretrial release and detention decisions not on evidence of individual risk, but on whether someone can buy their way out of jail? What sense does that make? We don't tell people you have a right to trial by jury if you can pay for it. We don't tell them you have a right to a lawyer if you can pay for it. We don't tell them you have the right to be presumed innocent until your guilt is proven beyond a reasonable doubt if you can put some money up. And yet we have this right to be presumed innocent and to be released until you have your trial on the merits if you can pay for it. It just made no sense to us.
What used to be a $100,000 bond on a murder case, that used to be a normal bond. Seemed adequate. Now, we're talking about bonds that are $5 million, $6 million. Holy mackerel, that doesn't make sense. Low offenders, we have to get away. We have to amend the Constitution. Our Constitution won't allow preventive detention. If we're going to address this in a different way, we have to figure out how we're going to do it and work it out and propose a constitutional amendment that'll get accepted, and then set up a more realistic and proper and accurate and better functioning system for determining who should be detained prior to trial and who should be released. And I think all of us in this room and everybody agrees that it shouldn't be based on a person's ability to pay.
You know, looking forward to this discussion, it's going to take some time, and I do think that looking at the whole picture, you cannot really do this piecemeal. You really have to invest all of what we have and all of our backgrounds and our wisdom into this endeavor together.